You moved out, you cleaned everything. You handed back the keys and felt good about it. Then the message arrived. Your deposit was not coming back in full. Half of it was gone. The reasons given barely made sense. Before you accept it, before you write it off and move on, I need you to hear this. What happened to you is not just unfair. In most cases, it is illegal. And there is a process entirely within your rights to get that money back. Welcome to the Scribe of Law. Quick note before we start. This video is for education only, not legal advice. Laws vary by country, state, and jurisdiction. Always consult a qualified lawyer for your specific situation. Now, let us get your money back. 3 things decide every deposit dispute. First, what your landlord is legally allowed to deduct. Second, whether they met the legal deadline. Third, what evidence you have. Get all 3 right and you will win. Miss any one of them and you may lose money you were owed. What can your landlord actually deduct for? The legal answer is narrower than most people expect. Your landlord can deduct for damage, actual, avoidable damage that you caused. A burn hole in the carpet, a large crack in a wall tile, stains that were not there when you arrived, broken fixtures that were working when you moved in. Everything else is covered by normal wear and tear. The gradual deterioration of a property through ordinary everyday use. Faded paint on walls, carpet fibers flattened in high-traffic areas, small scuffs on skirting boards, tiny nail holes from hanging pictures. These belong to the landlord, not to you. Here is the practical test. Ask yourself, would a reasonable person living normally in this property for the same period of time have caused this? If yes, wear and tear, not deductible. If no, it is damage, potentially deductible. Apply this test to every item on your landlord's deduction list. A real example. Imagine you lived in a flat for 2 years. Your landlord charged £300 for professional cleaning and to repaint 2 bedrooms. Both charges should be challenged. 2 years of ordinary living means faded paint, and a flat left acceptably clean is not a professional clean charge. Challenge both, in writing, with evidence. Now, the second thing that decides your case, and this is the one that most tenants miss entirely, the deadline. Your landlord does not have unlimited time to deal with your deposit. The law gives them a specific window after you vacate. Miss it, and in most jurisdictions they lose the right to make deductions at all. Not reduced deductions, not smaller deductions, no deductions, full deposit returned. The windows vary by country. In most United States states, 14 to 30 days after you vacate. In England, 10 days after you formally request return. In Canada, typically 10 to 14 days depending on province. In Australia, 14 days, sometimes sooner. If your landlord has already missed their window, your dispute just became significantly easier. In some U.S. states, the penalty goes further than just losing deduction rights. Wrongfully withholding a deposit triggers penalty damages. California allows 3 times the deposit amount. New York, double. Texas, 3 times, plus attorney fees. Judges award these in ordinary tenant cases every week. In the United Kingdom, there is a completely separate penalty rule that is even more powerful. If your landlord failed to register your deposit in a government-authorized protection scheme, within 30 days, you can claim between 1 and 3 times the deposit as compensation, on top of getting the full deposit back. The schemes are the Tenancy Deposit Scheme, the Deposit Protection Service, and My Deposits. Evidence is where most disputes are actually won or lost. Not in the paperwork you file. In the quality of the record you built before anything went wrong. Your landlord will make claims about the condition of your property. Your job is simple. Prove those claims wrong. And you do that with documentation created at the time, time-stamped, independent, impossible to dispute. The most powerful single piece of evidence is a video walkthrough taken on move-in day. Not photographs. Video. Film every room, every surface, every mark that existed before you arrived. Narrate what you see as you walk, then upload to cloud storage immediately, which gives it an independent timestamp. Do the exact same thing when you leave. same rooms, same order, same angles. This creates a before and after record that is almost impossible to argue with. If damage appears in the move-out footage but not in the move-in footage, your landlord may have a case. If it appears in both, it was already there. Case closed. Beyond the videos, save every written communication between you and your landlord. Every text, every email, every letter. Pay particular attention to any message that mentions the property's condition, repairs, or the deposit itself. Your landlord must also provide you with a written itemized deduction list, specifying exactly what they are charging for, why, and the precise cost of each item. If they give you a vague figure with no breakdown, that is not legally sufficient in most jurisdictions. You are entitled to specifics. If they cannot provide them, the deduction has no legal standing. If repair receipts are provided, check them. Landlords are permitted to charge only the actual, reasonable cost of restoring the property to its original condition. They are not permitted to use your deposit to fund upgrades, renovations, or premium contractors. If a receipt looks inflated, get an independent quote for the same work. The difference between their quote and the market rate is the amount you dispute. Before sending any formal communication, build your evidence file. One folder, digital or physical, containing everything. Move-in video, move-out video, all written communications, the deduction list, any receipts or quotes, and your original tenancy agreement. Organized, dated, everything in one place. When you submit a dispute, this folder is your entire case. One thing you do not need: a lawyer. I want to say this clearly, because the assumption that you need legal representation is one of the main reasons tenants do not pursue disputes they should win. The process I'm about to walk you through was designed to be navigated by tenants themselves. You can do this. There are 3 routes to recovering your deposit, and you follow them in order. Route 1, the formal demand letter. Route 2, the relevant housing authority, deposit scheme, or tenancy tribunal. Route 3, small claims court. Start with Route 1. Most cases do not need to go further. Route 1, the demand letter. Send your landlord a formal, dated letter or email. State the full deposit amount owed, state your legal basis, that normal wear and tear is not deductible, that the deadline has passed if it has, that specific charges are unsupported. Give them a specific deadline to respond. 14 days is standard. State clearly that failure to respond will result in escalation. Keep the tone entirely factual. No emotion, no apology, facts, law, deadline. Why does the demand letter work so often? Because it signals to your landlord 3 things simultaneously. You know your rights. You have organized your evidence. You are willing to escalate. The average landlord who is unlawfully withholding a deposit does not want to defend that position formally, because they know the evidence will not support them. The letter gives them an exit. Most take it. If Route 1 produces no satisfactory response, you move to Route 2. The specific process depends on your country, but the principle is the same. Escalate to a neutral body with legal authority to investigate, mediate, and make a decision. United Kingdom, Route 2. If your deposit was protected in a scheme, contact that scheme directly and initiate their Alternative Dispute Resolution Service, known as ADR. It is free. The adjudicator reviews the evidence from both sides and makes a binding decision, typically within 28 days. No court, no solicitor, no fees. United States, Route 2 means contacting your state housing authority or a tenant rights organization. Many states operate free mediation services for deposit disputes. Some states additionally require landlords to hold deposits in protected accounts, and housing authorities can verify whether your landlord complied. If they did not protect your deposit as required, that failure alone may trigger automatic penalty liability before any hearing takes place. Canada. Contact your provincial landlord and tenant board. In Ontario, you file a T1 application, which costs $45. In British Columbia, the residential tenancy branch handles deposit disputes. In Alberta, The Residential Tenancy Dispute Resolution Service. Each province has its own body, but every one of them has legal authority to order deposit return and award compensation. Australia. Deposits are called bonds, and they must be lodged with the relevant state bond authority within a fixed number of days. This means a neutral government body holds the bond from day one, not the landlord. If there is a dispute, apply to your state civil and administrative tribunal. In most states, this is free, and a hearing is set within 4 to 6 weeks. Route 3, Small Claims Court, is the route that makes most landlords pay, without a hearing ever taking place. The moment you file, your landlord receives official court papers. For the majority of wrongful deposit cases, that document produces payment before a hearing is even scheduled, because now their conduct is attached to a formal legal proceeding on the official record, and most landlords do not want that. Filing costs between $30 and $300 or pounds, depending on your jurisdiction and the amount being claimed. You submit your evidence file. A hearing date is set. At the hearing, your landlord must justify every deduction item by item. If they cannot, the court orders return of the deposit, and in many cases, additional compensation. Here is your action plan. Starting today. Step 1. Gather your evidence file now. Find your move-in video, your move-out video, all written communications with your landlord, and the deduction list they sent you. If you do not have a move-in video, note that for every future tenancy. Step 2. Send the demand letter this week. Date it. State the full amount. State the legal basis. Give a 14-day deadline to respond. Warn of escalation. Keep a copy. If you can check whether your landlord missed their legal return deadline, check that first. If they did, include that in the letter. Step 3. If there is no acceptable response within your deadline, escalate immediately to the relevant authority for your country. Do not wait. Delays can affect your legal position, and they work in the landlord's favor, not yours. A reminder that works for every country. The universal principle behind every deposit dispute. Document. Demand. Escalate. That sequence never changes. Start with the evidence. Move to the letter. Escalate if you must. The law is designed to work in your favor. If you follow the process, let us bring this together. Normal wear and tear cannot be deducted. Full stop. Your landlord has a specific legal deadline and forfeits their rights if they miss it. Evidence decides disputes, and you build it before anything goes wrong. 3 routes exist to recover your money, and they escalate in that order. The one action I want you to take in the next 5 minutes, check whether your landlord has met their legal deadline. If they have not, that changes everything. If this video helped you, share it with someone going through the same thing. They need this. See you in the next one.